I know, I'm sorry. I promised you that the third part of Tola was coming next. It's definitely on its way, but some legal news dropped this week that I thought was worth a very quick video. You might have seen in the news that the Supreme Court of Pennsylvania overturned the conviction of Bill Cosby. Public debate went in a few different directions on this, and I thought that there was an interesting legal question at the heart of it that's worth confronting. But first, let me be really, really clear about what this video is not. You tend to find in these sorts of cases, and Australia went through a similar thing with George Pell last year, that there are commentators who come out of the woodwork who dismiss any and all public outrage as merely being uninformed. What I think is more helpful instead is to treat public outrage as legitimate and then bring in the technicality to inform how we process that outrage, what we do with the outrage, and how we respond to the outrage. In a very real sense, we shouldn't care what the technicality is. We should care that, once again, justice seems to have failed the survivors. To illustrate this point, in 1760, William Blackstone wrote that it was better that 10 guilty persons escape than that one innocent person suffer. Ratio there of 10 to 1. 25 years later, Benjamin Franklin changed the balance. It is better that 100 guilty persons should escape than that one innocent person should suffer. 100 to 1. But what happens when this ratio starts to look like thousands to 1? It's one thing to say to a group of people that they need to accept outcomes that aren't going in their favour. But what happens when it seems that the system never, or at least very rarely, seems to go in their favour? And this seems to be the perception that's developing around sexual assault. The standards of evidence are too high, the procedural barriers are too great, the survivors are not having their needs prioritised. And this gets us neatly back to the Cosby case. He was not found innocent. The court did not find that there was some reason to doubt the verdict or to disbelieve the survivors. This was a case that was entirely about procedure and what procedural justice means. So what happened? The key issue here is the Fifth Amendment in the US Bill of Rights. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment of a grand jury, except in cases that blah 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 blah. We'll skip that bit. Nor shall any person be subject for the same offence to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Ignore all of this except for this part here. For today, this is the bit that matters. Nor shall be compelled in any criminal case to be a witness against himself. The idea that you can't force a person to confess has been historically important. Even though we have moved away from using torture to compel confessions, it is a big deal to be forced to be a witness against yourself in modern criminal trials. Now, Australia does not have a Fifth Amendment, but it does have similar provisions in our laws to prevent a person from having to give information to their detriment in broad strokes. So, for example, here is Section 17 of the Commonwealth Evidence Act, and it says that this section applies only in a criminal proceeding, so it doesn't apply in civil proceedings, and a defendant is not competent to give evidence as a witness for the prosecution. So a defendant can choose to take the stand, but the prosecution can't call them as a witness. Now, as I understand it, and I am not an expert in this, in Pennsylvania, the Fifth Amendment can also be used as a shield for defendants in a civil case if there is some threat that the material produced for the civil case could inform the criminal case. okay, let's get away from the heaviness and seriousness of Cosby and use something lighter to explain what we mean here. This is Sailor Moon. She has very credible evidence that would prove, to a civil standard, that Sailor Mercury here negligently caused damage to her computer. What do we mean by to a civil standard? Well, in the United States, this standard is known as the preponderance of the evidence. Here in Australia, we know it as the balance of probabilities. Whatever the language used, we're not going to go too deeply into this, but we know that civil standard for proving a case is lower than the criminal standard beyond reasonable doubt. Beyond all reasonable doubt. Now we can rephrase the Sailor Moon story a bit. She has very credible evidence that is not necessarily proof beyond all reasonable doubt, but to a very convincing degree that Sailor Mercury negligently caused damage to her computer. Sailor Mercury is denying the claim, but she says that the only way to deny the claim would be to incriminate herself in something more serious. There is evidence that she has that would make Sailor Moon's evidence far less convincing, but would cause herself to be incriminated. Now, this might all seem a little bit far-fetched, but it appears to happen in drug-related cases. People called as a witness in civil matters might end up incriminating themselves for drug trafficking, for example, or other substance offences. Let's keep the moment there. Should a person be compelled to give evidence in a civil trial that might be used against them in a criminal trial? Your intuitions might reasonably go in a few different directions on that question. Sailor Mercury's lawyer, She-Hulk, can put in an application that Sailor Mercury's evidence is unable to be compelled because it might incriminate her. She might end up losing the civil case, but at least she won't have incriminated herself. This is approximately what happened in the Cosby case. There was a criminal investigation going on, and there was a civil case going on. Worse, unlike the Sailor Mercury case, a lot of the evidence needed to make the civil case work needed to be compelled from Cosby. Cosby was able to say in the civil case that the evidence was not compellable from him because of Fifth Amendment reasons. He would be compelled to give evidence that could be used against him in the criminal case. So what happened? Let's go through the steps. The district attorney looked at the evidence in the criminal case and came to the not unreasonable conclusion that a successful conviction was unlikely due to the lack of sufficiently credible and admissible evidence. But if Cosby was compelled to give evidence in the civil case, there was a better chance that one of the survivors would be able to get compensation. If there were no threat of criminal prosecution, there would be no Fifth Amendment shield. The district attorney decided to take away that shield. Now Cosby would be compelled to provide evidence in the civil trial, which he did, and he gave evidence that was incriminating. The civil case settled for $3.38 million. So let's just recap really, really quickly. By promising not to prosecute Cosby, Cosby then couldn't use the Fifth Amendment for the civil case, and therefore the civil case was successful and settled. Nearly a decade later, there was a new district attorney, and they decided to use the same evidence from the civil trial to prosecute Cosby. That district attorney absolutely knew about the state of play, but thought that they could go behind the problem through legal chicanery. At first instance, the trial court heard the argument about this arrangement not to prosecute and held that there was nothing binding the new district attorney from prosecuting Cosby. This is the key basis for the appeal. The Supreme Court on appeal says that when a prosecutor makes a promise not to prosecute and a defendant relies upon that undertaking to their detriment of their constitutional right to testify, the principle of fundamental fairness that undergirds due process of law demands that the promise be enforced. The Supreme Court at no point enters into a discussion about whether or not Cosby did or did not assault anybody. Instead, it turns to previous authorities about issues like prosecutorial inducements. Courts have an obligation to hold prosecutors to their word, to enforce promises, to ensure that defendants' decisions are made with a full understanding of the circumstances, and to prevent fraudulent inducements of waivers of one or more constitutional rights. So what's going on? The Supreme Court found that Cosby had lost his constitutional protections due to the promise of the district attorney. For the district attorney to use materials obtained only through removing that constitutional protection would be to violate principles of procedural fairness. It would be antithetical to and corrosive of the integrity and functionality of the criminal justice system. For that reason, Cosby's convictions were overturned. He was not found innocent. There was no questioning of the integrity of the witnesses. This was purely a question of process. All right, legal hats off. This is a hard pill to swallow. I personally just hate this. I can barely imagine the anger of people who can only see once again the justice system failing to prioritize survivors. And I ask myself two questions. The first question is whether or not we're down here in the murk due to earlier problems in the legal system. The thing that kicks off all of this was the district attorney forming the view that despite all of the evidence that was on the table, there wasn't enough material for a safe conviction. All right, why not? Is the standard too high? Is there something about admissibility of evidence that has made this standard unreasonably high? Is there something about admissibility of evidence that has made this unreasonably high? As a moral and just society, what is the right balance? Is it really 10 guilty men to one innocent man, or is it 1,000 guilty men to one innocent man, or is it somewhere in between? At what point of letting guilty men go free do we think that there is a problem with the evidentiary burden of securing convictions? The second question I have is how comfortable I am with the fact that there are people that we know for dead certainty that they are guilty, but we cannot obtain convictions for what seem to be, and in my heart of heart, I think are, very esoteric reasons. At some deeper level, I think that guilty people should be punished, and it seems to be a failure of the system that there are people who are untouchable by the legal system simply for technical reasons. It hits me right in the gut, and even though I think that executive power of the state needs to be controlled and that criminal convictions need to satisfy a high bar, it just feels wrong that there are people who can get away with things that we know that they did. I don't think that there are clear-cut answers to these questions, but they are questions that are worth discussing properly and with a full set of facts. I hope that this outline was helpful. Feel free to take this topic up with me more on Twitter over at Legal Reckoning, and I will see you next time for what I hope is Tola Part 3. Bye-bye.